Welcome to the Celebrity Estates Wills of the Rich and Famous podcast. In this podcast, we break down high-profile celebrity estate planning cases for advisors and their clients. Most celebrity estate catastrophes are based on the same issues that everyday people face, just with the volume turned up. Our goal is to identify and extract the individual estate planning issues that lie at the heart of each story. We then discuss what advisors should expect and how to avoid common pitfalls. Hosted by WealthManagement.com Senior Editor David Lenok.
Hello, everyone, and welcome to the latest episode of WealthManagement.com's Celebrity Estates Wills of the Rich and Famous. For anyone new to the podcast, in each installment, myself and a guest take on a different celebrity estate and attempt to extract some key lessons that planners can apply to their more traditional clients. The idea being that celebrity estate planning stories, although often ridiculous in their details, generally have at their cores very basic issues that can just as easily apply to non-famous or fabulously wealthy clients. To learn more about estate planning and how you can better serve your clients, visit wealthmanagement.com/trust-estates. Our monthly journal features tax law updates, wealth planning, retirement strategies, and much, much more, written by thought leaders in the industry. That's wealthmanagement.com/trusts-estates. Today, we're joined by Brian Dillon. Brian is the partner in charge of the Minneapolis office for Lathrop GPM. Brian's an experienced litigator who specializes in trust and estate litigation, complex business and shareholder disputes, and responding to government investigations and enforcement actions. In the trust and estates area, Brian represents professional fiduciaries, individuals, families, and other interested parties involved in disputes over the validity or interpretation of wills, trusts, and other testamentary vehicles, as well as contested matters involving guardianships, conservatorships, and the rights of vulnerable adults. Thanks so much for joining us, Brian.
Thank you, David. Nice to be here.
The subject of today's episode is Lisa Marie Presley, the daughter of the king, Elvis Presley. Lisa Marie was one of the few inheritors of his estate, alongside his father, Vernon, and his grandmother, Minnie Mae. Lisa Marie was only 9 years old when Elvis passed in 1972, so her inheritance was held in trust under the stewardship of first Vernon and subsequently her mother, Elvis's ex-wife, Pricilla. Lisa Marie inherited Elvis's whole estate, including Graceland, on her 25th birthday, Vernon and Minnie Mee having long since passed at that point. Due to these years of excessive spending and being bilked by his infamous manager, Colonel Tom Parker, Elvis's estate was worth $5 million at the time of his death, with only about $1 million dedicated to Lisa Marie before the deaths of Vernon and Minnie Mae. However, by the time Lisa Marie inherited Elvis's whole estate in 1993, the amount had grown to about $100 million, thanks to the very successful stewardship of Pricilla. Sadly, after years of addiction and generally poor business decisions, Lisa Marie had largely squandered her inheritance, with Graceland being the main valuable asset left in the estate. And Lisa Marie died sadly in the evening of January 12, 2023, after being rushed to the hospital as a result of cardiac arrest. After her death, Graceland and her trust were inherited by her daughters, Riley Keough and Harper and Finley Lockwood. Several weeks later, Pricilla Presley challenged the validity of an amendment to her daughter's living trust that named Lisa Marie's children as executors and trustees. The amended document purportedly removed Pricilla and Lisa Marie's former business manager, who were the original trustees, and basically completely cut Pricilla out. Per Priscilla's allegations, Lisa Marie's signature appears suspicious in the 2016 amendment, and the documents had no witnesses. It misspelled her name and was never given to previous trustees for review, which was sort of one of the conditions for changing the trustee in the trust document itself. Pricilla and her granddaughter Riley reportedly aren't really communicating and are set to battle it out in court. Brian, in your experience, how common is it for an estate to head into litigation like this one?
I guess I would say it's certainly not uncommon, and it feels like, just from my own caseload, it's becoming more and more common. I guess what I'd say is circumstances matter when the testamentary documents, whether you're talking about a will or a trust, are poorly drafted or seem suspicious on their face, as seems to be the case in the Lisa Marie situation, with unsigned, unwitnessed, not all I's dotted, T's crossed, that kind of thing. The document's ambiguous. That's certainly going to raise questions. When the documents are either outdated or recently revised, revised close in time to the death of the decedent, particularly when they might change the allocation of assets in a way that heirs are caught off guard, in an unexpected way, or a way that conflicts with expectations of the likely heirs as they were sort of led to believe by the decedent during their lifetime. I mean, all of those things, any one of those things might be the trigger for a dispute, but multiple, more than one of those things in combination is certainly going to increase the likelihood. And then I guess I just say too, like, this is a general matter. I mean, people are living longer than they
Mhm.
used to, and they're amassing more wealth. And when people live longer, they live to see their children live to a more advanced age. And it's often the case where some children are, they need more, right? Their needs are different. And so when that happens, the typical allocation still to this day is you treat your kids equally, right? And it's an equal allocation between all the children. And when that does not happen, feelings, and it's unexpected, feelings can be hurt and people can get, motivated by different things. And so I guess it's a long and windy answer to your question. The basics are, it depends on the circumstances, but it feels like disputes in this area are continuing to happen more often, and I think are going to continue to kind of trend that way as the baby boomer generation, starts to pass on, and there's a whole lot of wealth that is anticipated to pass here in the next 5, 10, 15, 20 years.
So that was a whole lot of answer to what was only a superficially simple question, right? It was
Right.
an impossibly open-ended question I asked you, so I expected quite a bit of answer. So let's, I guess, start with by stating the obvious here, right? One of the things that sort of separates estate litigations from more typical sort of contract disputes, because that's a lot of what we're kind of talking about here, is that one of the parties is dead. And that's sort of the most important part, right? And that sort of presents its own challenges as, everyone is kind of left reading the tea leaves in terms of intent and what's suspicious and what's not, for sort of a lack of a better term.
Right. Well, I mean, in all of these cases, you hit it on the head, right? The intent of the decedent is always the North Star in these cases, and that's what courts want to carry out, the intent of the decedent. And when we're looking for the intent, we start with the documents that they executed during their lifetime. And if those documents are properly executed, right, they sort of meet all the formal requirements for a will or a trust or whatever it is we're talking about, a court is going to presume that they're valid, right? These are they have the decedent's signature. This is what they put in place. That nothing speaks louder than the document. But if there's a reason to question the document, and in these cases, the two most common reasons to challenge a will or a trust are lack of capacity by the decedent when they put the document in place, or undue influence. Undue influence on the decedent by someone or a combination of people prior to their death at a time when they were perhaps vulnerable or susceptible to influence. And typically these claims come up in companion, right? You
Yeah.
allege a lack of capacity and undue influence, and either one of those things could be enough to invalidate a document, even one that was signed. In the Lisa Marie case, I mean, the challenge doesn't seem to be undue influence or lack of capacity, but instead just that the document itself should not be treated as a valid modification of her estate plan because it's either not an authentic representation of her signature itself, or that it just doesn't meet the proper form, which is separate and apart from capacity or undue influence.
You keep talking about proper form
Mm-hmm.
and sort of terms like that, sort of execution.
Right.
These may sound like sort of very persnickety, lawyerly things, but in a case like this where the party's not there to verify things, they're actually super important. And particularly in the estate planning context, it's not uncommon to find multiple versions of documents of the same document with handwritten changes and different. I think just to give us a random celebrity example of a will, like, I mean, how many? First they found no wills for Aretha Franklin, and by the end of the thing, they found 5 or 6. And what sort of helps the court sort through this paperwork and just have any kind of sort of idea of what's right and what's wrong and what they can rely on are these standards and proper executions of the documents.
100%, right? And the proper execution rules can vary from state to state, but for a will, it's typically a little bit more rigorous. You need multiple witnesses, and in our practice, we typically want to use disinterested witnesses, just to separate any sort of self-interest of the witnesses from the execution formalities. But it can be a little bit more fluid for trusts, the formalities for executing and proper execution. But you're right. I mean, these rules are established for a reason, right? I mean, this is it's a very important document, probably one of the most important documents that anybody will sign in their lifetime. Sort of, how do I want my legacy to be handled after I'm gone, right? And so in order to sort of, I guess, recognize the solemnity of the document and the importance of it, we do put in place some pretty important rules to guide proper execution and enforceability of them.
You mentioned that trusts have a little bit more leeway in this regard. The trusts sort of are designed to be flexible, and that's kind of their purpose, right?
Right.
But how much leeway, I guess, how much control do those sort of four corners of the trust document have over what exactly the strictures for making certain changes are? I mean, in the Lisa Marie Presley case, right? It's believed that part of changing the trustee was just giving written notice to the previous trustee, which is pretty innocuous, even though it maybe didn't happen. But so,
Right.
how deep can the trust document get away with going? As you have to have like a sack race on non-consecutive Thursdays, and then there can, like how silly can we get, or is there some sort of baseline for how this works?
Yeah, it's a good question. And again, I think the answer probably will vary from jurisdiction to jurisdiction, depending on, there's a term of art, right? Bad facts make bad law. And a lot of times, if you have a bad set of facts, you might have a court that sort of goes out of its way to make a rule that is a little more onerous or maybe unintended, right? Have some unintended consequences. But most trusts will set up rules for how they can be amended, right? And a lot of times, a trust will say, this document can be amended by me, right? The person who is forming the trust, and in any written instrument signed by me prior to my death, right? And that's a pretty simple requirement. In the case of Lisa Marie, it seems like there were a few other, I would say, sort of form over substance kinds of requirements, right? Sort of notifying certain people, although there may have been some intention for including those notice requirements in the trust where they're found, right? And I think the more the paper trail and the evidence demonstrates that there was a real purpose behind some of these technical requirements, notifying the then current trustee or other people that the trust was amended, I think the more likely it is that a court is going to enforce them. But judges are human as well. And again, I mean, what it all comes back to is the intent of the grantor. And in this case, if the evidence demonstrates very clearly and persuasively that Lisa Marie intended this amendment to her trust to be effective, then that's what the court is going to end up doing. And I think depending on sort of the nature of the lack of technicality, if you will, all facts and circumstances matter. But again, the more evidence demonstrates that this is really what Lisa Marie intended, the more likely it is that amendment will be upheld.
And so, Brian, when you say evidence, our advisor audience might not know this, but depending on the legal procedure, not all evidence is admissible, even no matter how sort of final it could end up being in terms of determining something. There's strictures, under a contract, you're not allowed to bring in a lot of outside parole evidence. In this case, what sort of is any evidence of intent allowed? How far afield can these parties go to sort of provide evidence of what her intent was? That's because it's such a fuzzy sort of finding.
Right. Again, this is a jurisdiction by jurisdiction sort of an analysis, but in general, in these kinds of cases, hearsay rules and hearsay, for those who don't know, the technical definition is an out of court statement admitted for the truth of the matter asserted, right? So if someone were to come in to court and testify that Lisa Marie told me that she intended this amendment to her trust to be valid, well, that's classic hearsay, right? You're offering this out of court statement from Lisa Marie to be admitted to prove up that this was her intent. Typically, that's not admissible. Typically, hearsay is not admissible. In these kinds of cases, however, hearsay rules are often relaxed so that testimony about what Lisa Marie may have told different people about what she wanted to have happen, courts will admit it and they'll give it the weight that it deserves. And they do that because the decedent, again, it's what was the intent? I'm going to consider all the evidence. And if I find it to be credible, what I really want to do is implement Lisa Marie's intentions. And if somebody has relevant evidence, even if it might not sort of fall within the typical guidelines of the evidentiary rules, these cases are often litigated to the court, right, to judges and not juries. And when you've got a judge who is typically sitting there saying, look, I'm a lawyer, I'm trained as a lawyer, right? And I'm a judge. I sit here every day and kind of weigh the credibility of witnesses. If I find someone's testimony about what Lisa Marie may have told them to be credible, I'm going to hear it. I want to listen to what they have to say, and I'll decide whether I think it's true or not. The other sort of source of evidence that is often admitted in these kinds of cases are the records of the attorneys or professionals who drafted the documents, right? So attorney notes, communications that may have been that may have gone back and forth between Lisa Marie and her attorneys. Typically, that stuff is not admissible. You can't discover it because of attorney-client privilege rules and other confidentiality rules, and also hearsay rules, because the notes or the file might be offered to demonstrate what was Lisa Marie's intentions. In these kinds of cases, these are sort of one of the rare exceptions where that stuff comes in. It comes in routinely, and so the drafting attorney's file is often offered as evidence of intent of their client in putting an estate planning document in place.
Yeah, it really is interesting. Sort of, I think a lot of what you just said kind of illustrates how inconsistent and sort of not a sure thing, I guess, these sorts of, in so much as any litigation could be a sure thing, that these sorts of estate litigations specifically can be, right? You have all this sort of evidence that's not normally allowed. You have this element of who the judge is and what they happen to find credible. I mean, there's going to be a lot of overlap in that, but no two judges are going to find the exact same swath of people necessarily credible. So it does seem like there's a lot of play in terms of what's true and what's not in these sort of cases.
100%. And, a lot of times you're looking at, decades and decades of history, right? I mean, wills are amended and restated all the time. And so if you're really looking at, if I'm going into court and saying, well, I want to, there may be multiple iterations of a will or a trust that are relevant to the ultimate question of whether the most recently amended document is valid or not. And so you can be looking at, in addition to sometimes the flexibility and malleability of the rules that typically apply, you're looking at, lots and lots of history that could be potentially relevant to the issue.
Yeah, one other interesting thing, and this is sort of less universally applicable, but just like a fun thing about this one specifically, is the question of a signature and the validity of a signature is one of those interesting things that doesn't necessarily always come up. Like if this was an episode of Law and Order, and they were looking at sort of the various, you said there are numerous, unusual, things about this case. The one they would definitely focus on would be the abnormality in the signature. They'd have, some handwriting expert giving a PowerPoint and stuff. In a non-television context. So how realistic is, sort of checking the validity of someone's signature, especially signatures that could have happened, decades apart.
Yeah. In 20 years of practice, I've heard people talk a lot about getting handwriting experts, and I've actually seen it happen only a very small handful of times. I mean, it is often something that is questioned, but very rarely have I seen that be sort of the critical issue in the case. I'll be very interested to see how this one in particular shakes out. And I also, my understanding too is that the amendment at issue here, it wasn't notarized, it wasn't witnessed, and so the question of the authenticity of the signature is at issue. It seems like the authenticity of the signature is almost sort of just another reason to sort of challenge the technical compliance, right? We're sort of throwing everything at a wall at this point, but I don't know. We'll just have to see how this one plays out.
Yeah, this is one of those fun things in like a post CSI world where we all expect every police department to have like crazy,
Yeah. No,
DNA processing devices and things. It's like, oh, those handwriting stuff doesn't
yeah.
really come up.
Well, 100%. And, but this is, we often, and I know this is the point of your podcast, right? I mean, the things that come up in celebrity estates, they happen all the time in
Yeah.
non-celebrity estates, right? And what you often will see is sort of an elderly person who allegedly, modified his or her estate plan very late in their life when their handwriting was a little bit more chicken scratchy, right? And it's sort of like, well, is that her chicken scratch? Is that really what it looked like, sort of at that stage in their life, or is it a little too perfect, right?
Yeah.
And I mean, it's just you can come up with all the scenarios. I'm sure they've been litigated in some way, shape, or form.
So to bring things back and to bring it back to, I guess, the stuff that does really come up with more normal people, you mentioned the element that surprise can play in these sorts of lawsuits.
Right.
Obviously, if you're someone who's being cut out of a will is never going to be thrilled about it, usually, unless, they just really don't need it. But, in, sort of other contexts, sort of removing people from items, if you give them first of all, you can have the fight while everyone's alive. And second of all, it gives time for sort of emotions to simmer down a bit, right? Where, in this case, we're dealing with a large money sort of real estate situation. So, there was going to be a fight probably regardless when you were cutting someone out. But the idea that Pricilla just like found out about this when her daughter died is like, of course, she's going to have, a negative reaction initially to it. Like, oh, surprise, you actually have nothing, So even if it was valid, there's a chance she would still challenge it because it's like, well, what the hell? Because it's just like the natural reaction.
Right. Yeah, and I think Priscilla's issue was more about control. I mean,
Yeah.
my understanding is that Lisa Marie's interest in Graceland and some of the other memorabilia was put in trust, and the change in her estate plan, essentially indicated that at her death, Pricilla would not be the trustee of this trust, but Lisa Marie's children would be the trustee of the trust going forward. And I think that's the issue there, is that Pricilla wants to be able to control sort of how these assets are monetized going forward, how they're allocated, et cetera. But you're right. I mean, the issue of surprise, that is almost that is a common thread, right? Surprise or just sort of an allocation that is sort of questionable on its face. And a lot of these disputes could be avoided if the decedent, could have those hard conversations with family members and others who might be disappointed in their decision while they're alive. They're super hard conversations to have. Clients will often ask us, as their counsel, to have those conversations for them. Sometimes invite their children into the conversations about their estate planning, succession planning, particularly when like businesses are involved and family-owned businesses. And here's sort of the plan to allocate the business interests going forward. But being transparent about that and having the tough conversations with your kids and others who have a potential interest about, look, these are my intentions, and you might not like it, but I know what I'm doing, and this is what I want to do, and you might not like my reasons for it, but it's not your call, right? These are my assets, and I'm going to do with them as I please. It's a hard thing to do, but if anyone suspects that there's going to be a potential dispute after the fact, that those kinds of conversations can really help to ward that off.
And yeah, you specifically mentioned the reasons, right? That's one of the biggest parts of that, is that, they can tell whoever they're, why. This is why I'm doing this. Because when that is left to the imagination, now you're sort of like, okay, well, go ahead, 40 years of daddy problems, figure,
right,
run wild, as opposed to saying like, well, Steve's a drug addict and you're gainfully employed, and Steve's going to need it better, and he's going to need it more, so I'm giving him more, as opposed to like, you always liked him better.
Yes, 100%, right? It's just hurt feelings, right? It can be hurt feelings, and all the kids thinking, well, what, did he love you more than me? No, that wasn't it. He just, he has more needs, and you're self-sufficient, and you'll be fine. Or, I supported you during your lifetime, right? And there was sort of a disproportional level of support during it. So I'm gonna sort of make things right at my death. And,
Mhm.
as long as someone has capacity and they are not being unduly influenced, they have the right to do whatever they want to do with their assets. They can give it away. They can give it to one person instead. Everybody has the free will as long as they have capacity and are not being unduly influenced.
Yeah, and that kind of ties back into two of the other things you talked about, sort of that children's needs are different, right? That the idea that what is equal anyway at this point is really sort of rapidly, if it ever was
Right.
actually an egalitarian way of doing things, it's quite quickly being exposed as like not really holding up anymore.
Right. Well, I
Um,
say
and
this to my 3 kids all the time, right? Fair is not equal and equal is not fair.
yeah, and plus everyone living longer, you're having more time. There are more parties to enter the
Yep.
equation, right? It's like, okay, well, if one child has all the grandchildren, then how are we counting? What's equal now?
Right.
Because it's still, how so it complicates these. The longer everyone's alive, and the more you try to stick to a strict interpretation of egalitarianism in terms of that and being fair, the more complex that sort of idea can get in these sorts of things,
Right.
and the more room for uh, complaint and conflict that creates. So to close things off, you mentioned the dual sort of things of lack of capacity and undue influence. You see that those two things kind of come up together. Um, and what are some of the more common sort of, I mean, for, obviously if I'm a financial advisor, I'm seeing probably the client more often than
Hmm.
than the estate planning attorney certainly is, hopefully. What are some things that advisors themselves, could sort of look out for? In your case, what do you see come up maybe over and over again in fact patterns in cases where lack of capacity or under influence is present in these sorts of things? Because inevitably the advisor is going to get dragged into this,
Yep.
and hopefully they can play some role in sort of trying to head it off,
Yep.
potentially before it happens.
Yep. So, capacity in general in this context is actually a pretty low bar. In general, as long as someone is of sound mind, which courts generally interpret to mean, the ability to understand just the property that they own, sort of in a general level, and those who would naturally inherit their property, along with sort of the basic consequences of the allocation. Um, that is enough, right? So someone can have a formal diagnosis of dementia or Alzheimer's and still have capacity, right? As long as they can sort of hold those basic concepts in their mind, what they own, who would be the natural inheritors of their property, as long as they can hold that in their mind long enough to make a decision about how they want their assets to be allocated, they can have capacity. Somebody who's subject to a guardianship or a conservatorship can still have capacity. Um, in this context, it's often the case that people who are close to the decedent will be called to testify, sort of about anecdotes. What sort of things were they able to hold conversations about? How did they go about their day to day? Were they able to complete crossword puzzles, for example, or talk about the news, or could they give directions to a place that, to their home, for example, just things that sort of anecdotal evidence that demonstrates just some level of intellect, right? That is
It's just so
circumstantial
crazy to
evidence.
think that
Yeah, right.
that little
But I mean,
things like that, like a multi-million-dollar lawsuit, could be determined by whether or
100%,
not the decedent was able to complete the New York Times crossword puzzle that morning.
100%, right? But those are the kind of anecdotes that investment advisors will often remember, and to the extent that can be documented in real time while the person is still alive before there is a dispute. I mean, that's why I say like an estate planner's file, the most compelling evidence is the documentation of the decedent's intellect while they are still alive, and whether that comes in, in this day and age, video form, right? Or handwritten notes or somebody's diary. But before there's a dispute, before sort of lines in the sand are drawn, the paper trail or the video trail on what this person was capable of, and sort of their level of intellect, that's the kind of stuff that really matters. Um, undue influence is also, and lack of capacity in order to invalidate an estate planning instrument on grounds of lack of capacity. The evidentiary bar is typically very high, right? Instead of just a preponderance of the evidence, which is 51% more likely than not, you typically need clear and convincing evidence that a person lacked capacity. So in addition to a presumption that the document is valid if it was signed and kind of properly executed, if you're going to argue that the person lacked capacity, you're going to have to demonstrate with clear and convincing evidence that somebody lacked capacity. And the same is true for undue influence, right? I mean, it just sort of demonstrates that courts are really reluctant, if the document is sort of valid on its face and sort of checks all the formality boxes, courts are going to be really reluctant to overturn those documents unless they're given pretty powerful evidence that somebody just didn't understand what they were doing, or that they were being unduly influenced. And undue influence is, in general, the concept is that whoever was influencing the decedent to modify their estate plan, that their influence was so dominant over the person that the document itself really does not reflect the free will of the decedent, right? And that it reflects the will of the influencer. And there are a number of factors that courts typically will consider. Things like, the decedent's susceptibility to influence, right? Were they in kind of a vulnerable state? And that's where the capacity question is always relevant to the undue influence analysis. But also things like, did the influencer have the opportunity to exert this influence, and did they have the disposition, right? Are they the kind of person that would be inclined, and did the influencer benefit, from the influence in some way? So multi-factor test, but in general, very high bar, and very, very difficult to prove.
Yeah, I think it's interesting also to remember about undue influence. It sounds like one of those things which doesn't necessarily have to be malicious. Right? It's so easy when you're such an evocative term, undue influence, where it's so easy to just picture like, oh yeah, this is like the evil stepmother who cut everyone out, or this is the the aide who gradually wormed their way into the good graces of the person and then eventually kept them away from their family. But like a lot of times, this is just whoever the closest child is has the parent's ear more than the other ones do. Whoever lives closer. It's not necessarily always. It can be pretty otherwise innocuous seeming situations. It's not always as sort of malicious as the term itself makes it sound.
Well, yeah, and I think a lot of times, undue influence is alleged, or it's at least, the brother or the sister who receives less of a percentage of the estate, or is cut out of the estate entirely. They can't believe that the decedent would ever do that, right?
Yeah.
Certainly they weren't of their right mind if I was cut out of the estate plan, right? So by definition, there must have been undue influence. And it's not that simple, right? I mean, typically, in order to prevail on an undue influence claim, you do have to, there's almost always an element of sort of malintent or just bad conduct by the influencer. If the influencer is just, hey, look, I was the caretaker at the end of life, and I wasn't involved in taking mom or dad to the attorney's office, or I wasn't involved. I didn't sit through these meetings. Like, I wasn't the one that precipitated this. This was mom or dad's decision, and it makes sense. I'm the one that was, I was the caretaker at the
I was
end
the one
of
that was
life.
there.
Yeah, like if there's a reason for it, if it makes, I mean, that a lot of this stuff is just sort of gut check, right? Does it make sense? I mean, would someone in their right mind do this, or is this just sort of a radical departure with no rhyme or reason to it? You can typically, sometimes it's really complicated, but sometimes it sort of jumps off the page.
Well, that's about all the time we have for today's episode. I first like to thank Brian Dillon for being a really great guest, and really, explaining a complex topic. He sort of just got thrown, explain estate litigation to everyone. That's quite a bit to go over in a 30-minute conversation. So thank you for doing such a good job of it, Brian.
Happy to do it, David. Thanks for inviting me.
And for all listeners, I'll see you, or I guess you'll hear me, on the next episode of Celebrity Estates, Wills of the Rich and Famous.
Thank you for listening to the Celebrity Estates Wills of the Rich and Famous podcast. Click the subscribe button below to become notified when new episodes become available. The information covered and posted represents the views and opinions of the guest and does not necessarily represent the views or opinions of WealthManagement.com. The content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investment planning.